In the last segment, we were talking about whether one of these torts, which torts are often addressed through insurance policies. Would an insurance policy be available to cover a tort like family violence? What's your thoughts on that?
At this time, I don't think that the homeowner insurance policy would cover a tort of family violence. Those torts usually have an element of criminality to them, and most homeowner policies have exclusions for criminal acts. So you wouldn't be covered if you were committing actions that were intentional and they were of criminal nature. Most of the time, there are specific exclusions for that.
What if there's for example, a multi-generation family home where the homeowner has the policy, but another person in the home is the one engaging in the abuse? Then could there be a negligence claim then that it was the homeowner who was negligent for failing to intervene in some way related to the abuse, Heather?
There could be a negligence claim there. However, you would also have to look at whether that person would be considered an insured under the policy. Because if you're suing another person and that person's also an insured under the policy, again, there might be an exclusion for coverage.
Really fascinating insight there. Now, Andrew, this case, the award was for $150,000. What factors are relevant to the court when determining what the award for damages is going to be? How does the court determine what that amount will be once family violence has been found?
Well, when you read this case, you see that the first award of damages was $50,000 in compensatory damages. So the idea of that is to compensate her for her damage. She's going to need medical treatments. There's other issues that flow from that. And the judge commented it could have been higher than $50,000. Then she also found an additional $50,000 as aggravated damages due to the overall pattern of coercion and control that was exhibited by the father. And then lastly, she awarded another $50,000 in punitive damages because his behavior deserved that strong condemnation from the court. And each amount of that is what totaled $150,000. And it's interesting to note, you can see they're all round numbers. So if you're looking for something that would be a black letter adding up a bunch of numbers to get to 150,000, that wasn't there. I think at the end of the day, the judge is trying to do what she thought was right based on this particular case, and probably including some of the finances of this family.
Now, Dawn, in this case, there was a finding of what's called coercive control. And a lot of the other conduct in the marriage, assault, battery, those are all listed in statute and explained in statute. But coercive control isn't there. What is coercive control, and how do you make a finding of it? How would a court make a finding of that?
Well, coercive control is essentially, it's a calculated behavior. It's a calculated coercion. And it is mentioned in the Divorce Act in Section 2 under the family violence section. Now, you're looking for patterns of behavior, things that are designed to isolate the victim, things that's intimate partner violence. So it's basically acknowledging that there are certain behaviors that are conducted by parties that do cause different types of damages.
Heather, what would the benefit be of making this its own tort? Why not treat these as individual allegations of wrongdoing? What benefit is there in rolling everything into one new tort?
One of the benefits of rolling it into a new tort is recognizing that the behavior that's being performed is different than just an assault or a battery, that there's something unique when you have a family relationship and it's being abused, and that intimacy between people creates a very heightened level of trauma. And then the other benefit of having it in a specific tort is that it captures what's happening and it can be dealt with in the family law proceeding. And I note that Justice Mantane, before she was a judge, she worked at the Ontario Human Rights Commission. So I suppose that her background in human rights allowed her to say that the forum of the family proceeding was sufficient to deal with the tort family violence.
Dawn, we've got about 30 seconds. This judge certainly seemed to be very abuse-informed. How common is that in family court settings?
I think it is very common in family court settings. However, I think that prior to the tort of family law violence, there are limits to what the bench could actually do. So people were well aware, but the acts, the statutes themselves limited what they could actually do in terms of recourse.